Hi, I'm Utsav Mukherjee, an intellectual property and technology lawyer based in New Delhi. I'm affiliated with a law firm here. I'm starting a video series today on new and upcoming legal and policy developments in the intellectual property and technology law space. The purpose of this series is simply to spread knowledge and awareness on intellectual property and technology law. Any views or opinions that I express in this video series would be mine alone and would not represent the views or opinions of any other person or entity. So, as you all know, with the massive growth of the digital economy, e commerce, digital marketing, and social media have become very, very relevant in the business world. And there are hundreds of legal issues that are cropping up each day, which are being addressed slowly by people working in the law and policy domain. A lot of these legal issues happen to fall within the ambit of intellectual property and technology law, which are my areas of specialization. So, today I'm going to talk about a topic which is more relevant to technology law in particular, not so much IP, but nevertheless relevant. And this is the regulatory regime around digital economy and social media, right? Around influencers, specifically in digital economy and social media. So, let us first understand what are influencers, what is their relevance. Influencers are people with a lot of natural charisma and charm. They are able to sway audiences and their opinions through their videos, through their writing, through their reach. They're generally celebrities, sports persons, people who have a lot of appeal. And as a matter of fact, between $2.5 billion were raised between 2018 and 2022 by influencers in India's creator economy. Influencers being YouTubers, vloggers. Vlogger is an interesting term which today means video blogger, if you must know. And this whole market of Indian influencers is already valued at 900 crores today. And it's expected that it could go up to 2,200 crores by 2025. So that's how relevant influencers are to today's economy. So recently, two new sets of guidelines have been released that pertain to influencers. One is the guidelines for influencer advertising in digital media by the Advertising Standards Council of India, also known as the ASCI. And the other is the Guidelines on Prevention of Misleading Advertisements and Endorsements for Misleading Advertisements 2022, released by the Central Consumer Protection Authority, or the CCPA, which was established under the Consumer Protection Act of 2019. So, before we get to the actual guidelines themselves, I must tell you what are these two bodies, the ASCI and the CCPA, which I just referred to. So, the ASCI, or the Advertising Standards Council of India, is a voluntary self regulatory organization that implements self regulation in advertising. One can say that it regulates the entire marketing communication ecosystem, which comprises of advertisers, agencies, the media, and now even influencers. And the CCPA is an authority that has been established under the Consumer Protection Act of 2019, which is the new statute or consumer protection laws, the one which replaced the earlier Act of 1986. And this body, the CCPA, looks after consumer rights and interests. So while the ASCI also in its own way safeguards consumer rights, it only does so with respect to advertisements, but the CCPA ensures overall protection of consumer rights. So now that's about the bodies. Let's get to the actual guidelines. First, let me talk about the ASCI guidelines. So the ASCI guidelines define influencers as people who have a lot of sway, and they are able to influence the choices of their audience, as I've explained before, and they are able to do so because of their authority, knowledge, position, and relationship with their audience. And this includes both real influencers, such as celebrities from the film and sports world and popular YouTubers, as well as virtual influencers, which are the avatars of these famous persons. And the guidelines have some very clear intent mentioned in their very preamble. The preamble to the ASCI guidelines states that since the lines between content and ads have become blurry, it is important for consumers to know when something is being promoted for a commercial purpose, for commercial gain. That is when a particular celebrity or a particular influencer is promoting something because they're receiving money in return. So, this intent of these guidelines makes a lot of sense because content today is very indirect and disguised and often intended to make you buy something or subscribe to something, on social media, on other forms of popular media. And I feel there's nothing wrong with that kind of marketing. It's just that the intent behind these ads online needs to be very, very clear. It needs to be clear that a certain influencer is promoting something because they're getting a monetary benefit, so that the public knows that okay, this is why they're promoting it. They're not falsely persuaded into buying or subscribing to something. So how the guideline seeks to ensure this is that it makes these influencers disclose any material connection that they have with regard to something that they're endorsing, some product or service that they're endorsing. And material connection here includes not only monetary compensation, but anything of value that an influencer receives for endorsing a product or service, even things such as discounts or offers. So, what is the manner of disclosure which must be made? That is also specified in these guidelines. And it's pretty intense if you ask me, because the guidelines clearly state that disclosures have to be very, very visible and out there. They cannot be buried, say, in hyperlinks or the about section of a particular photo or video. In fact, if it's a photo or video, the disclosure must be superimposed on the said photo or video as per the guidelines. If it's a live stream, then the influencer must announce at the very beginning or end of the broadcast that they have a connection to the product or service that they're endorsing. And not only this, the guidelines actually mention the specific labels that have to be used as disclosure, such as advertisement, ad, sponsored, collaboration, partnership, employee, free gift, whatever the nature of the relationship is with that particular product or service of the influencer. So that those are, like, in a nutshell, the ASCI guidelines on influencers. But if you are an influencer out there and you're listening to this, or even if you're a natural consumer, just a normal consumer, you must be thinking, what is the consequence of non-compliance with these guidelines? What happens if an influencer doesn't comply with this? So first of all, the influencer may receive a notice from the ASCI for non-compliance. And in response, they can submit a reply with supporting proof. But there's no direct harsh consequence of non-compliance as such, because the SCI is a body which exists only for self-regulation of members. It basically publishes reports on the compliance of the guidelines that it has put out there, and it generates these reports through the research that it does with the usage of technology, which it has obtained in collaboration with technology partners. But there are certain consequences of non-compliance with the ACI guidelines. It's not completely toothless. The ACI may raise cases of non-compliance with the government or relevant sectoral regulators to take necessary action. And further, you know, recently the ASCI even published details of non-compliant celebrity influencers, such as which included some giants such as Amitabh Bachchan or famous popular actresses like Katrina Kaif. And this could be embarrassing for any celebrity influencer. So those are the ASCI guidelines, but there are also the CCPA guidelines, as I mentioned earlier, and we must discuss the details of the CCPA guidelines also, because the CCPA guidelines are actually basically a reproduction of the ASCI guidelines, but the consequences of non-compliance are much more serious here. The CCPA has the authority, the CCPA or the Central Consumer Protection Authority has the power to impose penalties up to 10 lakh rupees on manufacturers, advertisements, and endorsers for non-compliances of the misleading advertisement guidelines. And they may even impose penalties of up to 50 lakhs for subsequent or second time contraventions. And further, if it still continues, they may prohibit the endorser or misleading advertisement from making any endorsement for up to 1 year, or for any, or even for up to 3 years in certain cases. So basically, for 1 to 3 years, you can be barred as an influencer from doing what you do best, which is your actual profession or business, influencing. If you carry on making misleading ads without making the necessary revelations of your connection with the product or service that you're endorsing. So that's basically the two sets of guidelines for influencers that are currently in force. And as far as my opinion is concerned, I think that it's a very good thing that there are clear guidelines out there. They are not really curtailing the influencer business. They're simply making it transparent. They're putting in place some very necessary and simple rules that are to be followed. And content today is very, very relevant. It practically drives the market and consumer choices. So influencers wield a lot of power, and as they say, with great power comes great responsibility. And these guidelines are just imposing that responsibility and clearing out otherwise murky waters. So it was great speaking to you all. I look forward to producing more episodes on developments in the intellectual property and technology law space. In this fascinating technology driven, open, and abundant market that we're now in. And I hope that you have a great day and a great week ahead. Thank you.